Hello and a very warm welcome to episode 6 of the Money Startup podcast. Can't believe we're at episode 6 already. Certainly very early days, but a lot of fun meeting some great people. So really hope everyone is getting a lot of value out of these sessions, out of these podcasts. As we've said before, this is the show for Australians all over the globe when it comes to all things personal finance, whether it's tax, investment, budgeting, cash flow, property investment back in Australia. We have got you covered. Huge thank you for joining us today. We've got a great guest speaker, which we will introduce a little later in the show. My name is Jarrad Brown, Senior Financial Planner here in Singapore, and I'm joined today by my friend and colleague, Kerin down in Perth. G'day, Joel.
Hello, Jarrad. How are you?
Not bad at all, thank you. Another beautiful humid day here in Singapore. With a bit of rain outside today, but otherwise not a lot of variation in our climate here.
No, we've got the hay fever season coming in Perth. I saw the wattles and I've been sneezing all morning. So let's fingers crossed we can get through this podcast without much pausing, let's say. But no, I am a senior financial advisor here at Ally Wealth Management in Perth. And before we dive in, I think it's really important that we just jump into our little quick disclaimer to keep our lawyers happy. Anything that we talk about here is going to be quite general in nature, and we really hope you get a lot of value out of it. But however, if you would like to have personal advice and how the stuff that we discuss is going to impact you personally, please get in touch and we can provide you appropriate personal financial advice.
Beautiful. Well, look, now that that's out of the way, let's dive into the good stuff. A busy time, end of financial year rapidly approaching. It's budget time. There's a lot going on for Australian residents and expats. Let's start with the budget. Joel, as an expat myself, felt a little boring reading this year's budget, I must say. Not a lot for expats, not a lot for property investors. Do you want to maybe just give us some of the headlines around how the budget impacts Aussie residents or even Aussie businesses?
Yeah, and you're probably right, Jarrad. The budget that came out on Tuesday was a bit boring. It was, broadly speaking, there's some pros, there's some cons, there's a lot of things that I suppose from a financial advisor we could have actually seen to be, quite proactive, it was just quite mute on those topics. But headline topics for the budget more or less are, the budget delivered a surplus of $9.3 billion. Obviously, that is in stark contrast to what was initially forecasted last budget of a $1.1 billion deficit. However, as anticipated, we'll probably roll into an election year. And I would say the unofficial election season is probably starting, with the government predicting a $28 billion deficit looming next year. So we're probably going to see some more positive changes and election promises coming out over the next, say, 12 months, more or less. The economy is projected to grow by 2% over the 24-25 year, which is obviously great, and then 2.3% in 25-26. A big thing that obviously has been the topic of basically every news article in Australia has been, housing. We're going through very much a housing crisis. Vacancy rates are still at record lows, sort of below 1% in every sort of jurisdiction across the country. And largely our capital cities. And a big influence of this is migration. We've got lots of people coming into the country. They obviously need places to live as well. They're skilled workers that we probably also need, but we're just not building houses fast enough to house these, and that puts a lot of pressure on that housing. So the government expects net immigration will sit at about 395,000 this financial year, and will reduce to 260 for 24-25. As I sit here, nice and comfortably in Western Australia, where, from a state budget perspective, we're sitting, quite in surplus. And a lot of that is driven by commodity prices, and Perth's economy is driven, quite broadly by commodity prices. So yeah, the government actually anticipate the iron ore price to drop to about $60 a tonne, which is currently sitting at about 100. Let's just talk about who the winners are in the budget, more or less. So anyone on sort of social security benefits, we've seen about a 10% increase in rent assistance to obviously help combat what we're seeing, broadly across every capital city is everyone's paying a little bit more in rent, and lots of investment going into things like precious metals, solar production. It was really, I would say, a topic of discussion to say that they're trying to make Australia the renewable capital, and this is going to be their platform to go on. And how do they do that? Well, we need to obviously have the processes, the metals, the everything that we need to make Australia a sort of renewable powerhouse. So there seems to be lots of tax effective strategies and tax breaks going towards these to get companies to get investment in this area, which is really, really good. Parents obviously benefiting as well from the budget. Superannuation will now be paid on parental leave. I saw this originally starting with the Queensland government. So if you were a Queensland public service employee, they announced this as well. But this has also flowed through to federal as well. So in the paid parental scheme, women or men will get paid parental leave. Electricity rebates are then also flying in. It seems to be, to combat the cost of living pressures. We're all getting a credit on our electricity bills, and businesses are receiving, again, rebates on electricity costs. So there, again, any sort of contribution to cost of living pressures is welcomed, of course. A freeze on PBS medications. We're keeping the PBS and all medications relatively cheap for pensioners as well. But I suppose probably one of the two biggest ones that came out of the budget was HECS. Now, this has been on the cards and, on the lips of, all of my TikTok followers and all the youth that we see. Last year, if you had a HECS debt, it was smacked with a 7.1% increase. So in some cases that I saw, the increase was more than the repayment. And so the government has actually decided to reverse that. They're now going to change how HECS, or the indexation rate on HECS, is going to be applied. So it'll now be either the wage growth index or CPI. So really, and whatever the lower of those two numbers are. So it's, very much welcomed, and that'll be also backdated to 2023 as well. So they can expect a sort of credit back to their HECS accounts. And then, of course, the stage 3 tax cuts take effect as of the 1st of July. That was already announced. That's already legislated. The Labor government tweaked that from the prior Liberal government. But generally speaking, high income earners will still be receiving a modest sized tax cut as well. That's sort of rounding out all of the winners, more or less, apart from, perhaps even there's more investment going into social housing. Again, touching on that housing topic, more or less. So, there was obviously that's all the best bits. The losers, look, there seems to be, a lot of unchanged stuff. So I would use the term losers less so than, it's just maybe you're not getting anything, more or less, and you've just been left sort of right out. Mortgage holders, we see no sort of immediate relief. We've seen benefits go into renters and social security recipients. But no relief as yet. We don't anticipate, obviously, any rate cuts coming by the RBA to ease off mortgage pressure. International students, obviously, there's going to be capped universities placements there unless the university contributes to housing to house those university students. And this is probably a very practical decision. If lots of international students come to the country to study, obviously they're going to need places to live. And having universities play a role in this could help boost supply, particularly for the international student environment. And higher income renters, there's no indication on, easing rental increases, particularly if you're not on social security benefits, or you're just having to wear the higher rental prices. Although, albeit though, you've got a little bit of tax saving coming on the 1st of July. But Jarrad, what about your thoughts on, how the budget has impacted, the expat community? I know that there was a small change or tweak coming with the non-resident tax rates. But yeah, how is the conversation going sitting in Singapore?
Yeah, great question, Joel. Look, I think this budget, as takes place many, many times, expats were kind of in the, as you put it, the left, right, out category. Really no updates or insights as to timing on the changing in the tax residency rules. So we'll continue to watch that space closely. As you say, the tax rates could be the big ones. So as non-residents of Australia, any of our taxable Australian income, which for the majority of us will be net rental income in Australia, that's currently taxed at 32.5% from $1. So a lot of expats make the mistake of assuming that we get the first $18,000 tax-free, but there is no tax-free threshold for expats. Now that 32.5% could be dropping to 30% from 1 July next year, also 1 July 2024, next financial year. Now, yes, it's only a 2.5% difference, but what it does mean is that if you're planning any maintenance repairs on your property, or you're planning to make a super contribution, or even if you're just looking to prepay some interest to bring forward those tax deductions, they could be working at 32.5% for you instead of 30% next financial year. Now, yes, it's only 2.5%, but 2.5% for not doing a great deal, probably better than a kick in the teeth. So I guess a bit of good news, maybe a bit of a call to action than anything else for expats. I think the other important one to be mindful of is the impact on the Aussie dollar. We've seen this budget really a bit of a non-event for equity markets, for bond markets, for cash rates, for the Aussie dollar, but it's kind of neither been inflationary or deflationary. We've seen a bit of cash thrown around, but with inflation so high and the cost of non-discretionary spending so high, our energy prices, utilities, groceries, all this stuff that we can't really control probably means that people are not going to be out spending this money left, right, and center. So, the good old days where $900 went out and JB Hi-Fi had more flat screen TV orders than they knew what to do with, I don't see that repeating. But I also don't see inflation falling off a cliff as a result of this budget either. So what that probably means, as you say, is that the cash rate's not going to drop anytime soon, which could also mean that other countries are cutting their rates before the RBA does. Now, what that could translate to and what that means for expats is that the Aussie dollar might actually strengthen a little bit from today. We've seen, sitting here in Singapore, the Aussie dollar relative to the Singapore dollar go from around 114, 115 only recently to around 110, 111 now. So that trend could continue a little further if we do see, say, the Federal Reserve in the US cutting rates before the RBA does in Australia. So I think that's probably the only material impact that we would see. As I said, from an asset class standpoint, quite a boring budget. For those with savings, term deposits, I guess might be good news in that rates probably aren't going to drop in the short term. So people can enjoy their 4.5%, 5.1% term deposits for that little bit longer in Australia. Certainly only a thing we could dream of here in Singapore. Interest rates on bank accounts at 5%. I think we're pretty hard pressed to find anything that starts with a 2, but better than the zeros we were all enjoying not that long ago. But yeah, that's a bit of an update as far as the expat space is concerned. Not really a lot in it.
Oh, well, at least there's some sort of small, let's call it a small win, more or less, and hopefully more to come. You touched on obviously the potential strategies as we roll into sort of end of financial year now. Still relatively soft Australian dollar. We've got that just sort of opens up a lot of opportunities for our clients and expats around the world to sort of take advantage of that sort of semi-weaker Australian dollar, or if we're sort of projecting it to get stronger, there is obviously some benefit there. It could be, for example, end of financial year super contributions to offset net income. It could be prepaying some interest on your mortgage, topping up your Australian investments, topping up your Australian bank accounts. These are all, I suppose, strategies that we're talking about broadly. But so I suppose, Jarrad, interesting to hear your thoughts as a expat. Is there anything particular that you're doing in the lead up to end of financial year?
Yeah, absolutely, Joel. Look, end of financial year, always a busy time, and definitely not one that we want to leave until late June because, hey, a lot of super funds are probably not interested in speaking to you as we get too close to the end of financial year. But yeah, look, certainly as an expat, I've got property back in Australia personally, as do a lot of our clients. So it's always a great time to, we're reaching out to our property managers, getting those sort of preemptive financial year summaries to work out what your property cash flow is going to look like, running interest statements on your loans so that you know what your sort of approximate taxable income is going to look like. And that just gives you a good snapshot of what the tax bill could be. So, rolling a bit into super, as you say, making that tax deductible concessional contribution this year up to our 27.5 limit. Next year goes up to 30,000. So again, a great chance to get a bit more money into super this financial year and offset that tax. It's also not a bad time as you're reviewing, if you do have properties in Australia, review the rent that you're receiving. It might be a good time to bump up the rent a little. Vacancy rates are at record lows. We are seeing rental prices continue to increase. So it's always a good time to just review that cash flow and even review the interest rate on your mortgage. Because if you have come off that fixed rate over the last year or so, or it's coming up, good time to review that and sort of explore your options in terms of what that looks like. But yeah, that's probably the big one we're looking at, Joel. Any repairs, maintenance on the property, again, trying to bring forward those deductions into this financial year. Repainting, fixing fences, whatever else it might be, fixing up gardens, etc. Just those sort of general tidy up repairs. Again, just to bring forward those tax deductions into this financial year.
Excellent. Absolutely.
Well, look, we might dive straight into our interview, Joel, if you're ready.
Yeah.
Today's guest speaker, we're absolutely delighted to have join us today. And before we cross to our interview, the topic we've sort of decided to cover off today is around estate planning, but estate planning from an Australian perspective. I think far too many expats make the mistake of either doing nothing because estate planning is just too morbid and hard and we can't find the time, or making the mistake of assuming, well, I've got an Australian will, I'm covered no matter what I do because I got told my Australian will is good enough no matter where I live. So we're going to unpack a lot of that. We're going to dispel some myths. We'll cross to the interview now. Let's do it, Joel.
Cool. Let's go.
So guys, look, a very warm welcome to our guest speaker, Gerard Basha of Bartier Perry today. Absolutely thrilled to have Gerard join us today, the estate planning expert, heads the estate and probate and tax for individuals and business succession groups, if I've got that right. Gerard, an accredited specialist in wills and estate law, a notary public, recognised as one of Australia's leading experts in this space. Estate planning, wills, powers of attorney. Joel, I'm sure you can confirm this. We see both Australian expats and residents getting this wrong all the time. It's just such a minefield. It's such a morbid topic for so many to think about. And whether it's I've already told my spouse what to do with my stuff when I'm gone, so that's enough. Or I don't know if I should have a will based on where I live. There's just so much to unpack. So Gerard, absolutely delighted you could give us your time today. I feel like we could probably spend hours on this topic, but we've tried to narrow it down to what will be useful to our listeners, to our audience today. Some for expats, some for residents. So if you're happy to, we'll dive straight into the questions.
Yes, thank you, Joel and Jarrad. Thank you.
Wonderful. So I guess let's just start with the basics, if we may, Gerard. Could you just give us a bit of an overview? What is estate planning and why is it so important for both Australian residents and expats to think about?
Well, it's important to realise that the inheritance law in different countries is very much influenced by the social, political and the ideologies of the particular countries, and that influences their laws. And so you need to be aware of what the law is in each jurisdiction that you may have assets in or that you may live in at particular times. So given that all over the world we have an ageing population and we have an increase in age-related conditions, prudent estate planning, wherever you are, involves planning for incapacity during your lifetime, but not death. Who will make financial decisions for you if you're not capable of making those decisions for yourself? Who will make healthcare decisions for you if you're not capable of making those decisions for yourself? Then we look at the post-death situation. Obviously, what's going to happen with my assets in Singapore, in Australia, in the United States, in my personal name? What about if they're in joint names with my partner, my spouse? What's going to happen with my interests in companies or trusts that may be located in different jurisdictions? What's going to happen with my employment entitlements, my superannuation from different jurisdictions? So ideally, prudent estate planning is covering the field, looking at all your assets and your interests and your office holdings and your control of family trusts and things like that, and trying to achieve a consistent plan that not only deals with what you own, but also what you control.
Makes a lot of sense. So, you touched on this a little bit, but I guess just to really hone in on this question that, we get asked all the time. If I'm an Australian citizen or permanent resident living in China or Singapore or the United States, is it just the Australian estate planning laws that I need to think about? Or do I actually need to think about the laws, the rules in that country of residence or where my assets might be?
Yes. I think it relates to where your assets are and whether you have significant assets in particular jurisdictions. Obviously, the revenue laws and the inheritance laws in different jurisdictions will be different. So if you have significant assets, and when I say significant assets, I might mean, real estate, significant shareholdings, significant bank accounts, for example, it's prudent, in my view, to have different documents in different jurisdictions to deal with the assets in that particular jurisdiction. And it's important to get advice about all the implications of dealing with those assets in each jurisdiction from qualified people in the jurisdiction that know the laws and know the practices in that jurisdiction.
I think you're starting to, those points are so valid in making sure that, where we've got our assets, that it's really, we've got documents and that take those assets into consideration and that can deal with those assets.
Yeah. So if I could just interrupt there, Joel, one thing I forgot to say, the more significant the assets, the more likely you are to require separate documents in different jurisdictions. But if you, for example, have most assets in Australia and you might have a small bank account in Singapore, for example, that might have the equivalent of $10,000 Australia in that bank account, you might consider it, and I'm not a big fan of them, but you might consider an international will in Australia. The only time I would recommend signing an international will is in that scenario where you have very minimal assets in another jurisdiction and you don't need to consider the inheritance laws or the tax laws or the revenue laws that impact upon that small bank account, for example.
It's a very valid point that you're raising there. So, we deal with Australian expats that, are constantly sort of moving all around the world, from Australia to different jurisdictions. What would you say would be, and I put this, the first steps that an Australian expat would take when beginning sort of to plan their estate planning needs?
Well, I think the first step, the logical first step, is to take stock of what you own and where it is. And the best way to do that is to have a listing of these are the assets in Singapore, these are the assets in Australia. It will help advisors if you can give, estimated values to the assets so that they know what they're dealing with and what might be the issues. If you've got existing documentation in particular jurisdictions, have copies of that documentation available. And stating the obvious point, if you don't have any documentation at all, but you've since acquired, significant assets in a particular jurisdiction, you need to make that point clear.
So when they are starting to deal with, or let's just say accumulate assets in different jurisdictions, more or less, how is there sort of a simple rule that sort of tests whether those wills or powers of attorney or stuff are valid in their country of residence?
That's a good question. I think that they probably need some advice on that, but my own feeling is that given the cross-border issues, it may be difficult to it may be more difficult to have an Australian document, for example, recognised in Singapore than it will be just to have a Singapore document recognised. So you have the conflict of laws issues. So rather than trying to jump through the hoops, and you may need a court application in Singapore to recognise an Australian document, it might be cheaper, more cost-effective and more prudent to just have a separate document in Singapore. Now, obviously, it depends on your particular circumstances, how significant the assets are in each jurisdiction and things like that. And going further about your point, Joel, when people start to, accumulate assets in different jurisdictions, and if the accumulation of assets is going to be significant, they may want to get advice early on, and not so much only the estate planning advice, but they may want to talk to experts like you about structuring and what's the most tax effective way of accumulating the wealth or acquiring the asset in that jurisdiction. And so, you don't necessarily have to wait until you're doing your estate planning. Also, structuring is important when you're starting out acquiring assets in different jurisdictions.
It's a really good point, and I think it flows on quite nicely to our next question, and that is around tax. So, if I'm an Australian citizen with assets in Australia, but I live in Singapore and my beneficiary lives in London, where on earth do I get started? What do I need to think about? Could there be tax implications in all three? What would the average person do?
Yeah, it does get complicated when you're talking about reasonable assets in different jurisdictions and what the tax impact might be. I can certainly speak to generally about the position in Australia, and the Australian tax laws, their reach is going further and further in the sense of, if you're, for example, we're talking about trusts and you have possible foreign beneficiaries in your Australian trusts, that can create adverse duty and tax consequences. So all those issues have to be worked through on an asset-by-asset sort of basis with proper advice in Australia. Overseas, likewise, I know, the US position with tax is quite complicated, but if you're an Australian resident, there may be issues about being taxed in both countries. So you need to work through that with particular advisors in each jurisdiction, depending on you looking into the crystal ball and assessing how significant is the issue going to be and how problematic will it be and how is it going to impact you.
Of course, if we all knew what everything was worth the day we die and where we're going to be, that's probably all be a whole lot easier, wouldn't it? Now, I guess the next question, and a bit of a morbid one, but I think relevant for a lot of our audience, and that is, what if I not only pass away without a will, but what if I'm overseas living outside of Australia at the time? Are there different implications, or would it be the same if I passed away in Australia?
Well, there are different implications. First of all, depending on your assets, what I refer to as the intestacy law, where you die without a will or a valid will apply. The intestacy law will be different in different jurisdictions. If most of your assets are in Australia, the Australian intestacy law, depending on which state or self-governing territory you live in, will determine who is entitled to your assets where you don't leave a will. Where it becomes problematic is that you've got the problems of proving your statutory relatives in an application to the court in Australia where you die overseas without a valid will. So it's a bigger issue in terms of, and cost in terms of what you need to prove when you don't have a will. First of all, you have to prove that you died overseas, and Australia accepts most Commonwealth country death certificates. But if you die in a country that's not a Commonwealth country, you actually need somebody to virtually say they identified your body, and that is sufficient proof of death in Australia. You may have left Australia when you were reasonably young. You go over to, say, for example, Singapore, and you meet someone nice, and you have a relationship, and you have children, and that goes on for years, and then you die without a will. It becomes very difficult in Australia because you then have to get the certificate evidence to prove, one, that you didn't have any de facto spouse at the date of your death. That's by way of an affidavit. But then you have to prove the marriage in Singapore. You have to prove, so that's a certificate from the appropriate authority in Singapore. You have to prove who your children are and that there are no other children. Usually in Australia, that's done at the Registry of Births, Deaths and Marriages, and you get a parentage search for children so that you can produce it to the court. So the court knows that the person who's proposing to administer your estate is the right person, the person with the interest in the estate, and that the court knows who are your statutory relatives so that they can basically oversee what this administrator is doing in Australia. But the bottom line is just do a will. Do a will wherever you are if you've got assets, because I'll tell you, as a lawyer that's worked on many intestacies, the problems are huge and the costs are huge and the complications are endless.
Yeah, very valid. It seems to be always a point that I tend to drum home with all of my clients, when we're speaking to them. It's a common question, do you have a will? And if it's no, it's like, well, why not? You need it. Everyone needs it. It just
and just to keep the message simple, the process is much simpler and less costly if you've got a will, a validly signed will.
Yeah, absolutely. So I know we touched, broadly on this earlier regarding tax, but, lots of favorite expat hubs, we'll call it, around the world, like the US, the UK, France, Asia, they've got laws sort of around inheritance or death taxes, more or less. How would you say that impacts, or how that could potentially impact, Australians that live in those destinations?
Well, not being an expert on those inheritance laws, the inheritance laws in those countries, what I can say is that I would imagine, from a general analysis, that if there are assets in those countries that were accumulated, obviously during the working and the living in those countries, I'm sure those countries would like to get their revenue to assist with their public works and things like that, their tax revenue, or whatever else they might call it. They may have inheritance taxes, depending on the jurisdiction. So I think that, once again, you've just got to get advice about, how the tax situation in the different jurisdictions is going to affect your estate plan, and what might come out, what might be left. And sometimes it's hard to get a definitive answer with any certainty because laws change all the time, especially revenue laws.
Absolutely. I'll direct my next question sort of a bit more closer to home. Sort of what role do you think superannuation will play in an expat estate plan? And is there any sort of special considerations that expats living abroad need to think about with their superannuation benefits, particularly?
Okay. All right. Well, starting from a superannuation benefit in Australia, where the fund is in Australia, and the rules of the fund are governed by a trust deed that's been prepared and set up in Australia. That will be the starting point for the rules relating to the distribution of your superannuation. It may permit binding nominations that have to be signed in accordance with superannuation law. that allow you to appoint a person to be the beneficiary of your superannuation death benefits. And Joel, as you're probably aware, there are a lot of tax issues surrounding superannuation, and if you appoint a person as a beneficiary who is both a dependent for tax and superannuation purposes, you get the more favourable tax treatment. So in the example of a partnership, husband and wife or partners living together, if you appoint your spouse, your partner, generally speaking, that's the most favourable tax treatment. If you've got, and it could be the case that you have superannuation in both jurisdictions. We've covered Australia, but there will be applicable superannuation legal requirements in the other jurisdiction as well. Now, I'm not sure how they structure their superannuation. I know, for example, that Australia is very good in terms of tax benefits and things like that. I'm not sure if those same benefits apply in overseas jurisdictions, but they're all issues that you can talk to advisors such as yourself about.
Absolutely. I was speaking to another estate planning lawyer a couple of weeks ago, and we were talking about the power of a binding nomination in superannuation. Obviously, superannuation is ordinarily does not form part of your estate, just by the way the laws work in Australia. So that binding nomination becomes, very important, whether and who it is paid to. Did you have any views on whether superannuation is more beneficial being paid to direct people or via the estate?
It's a good point that you raise, and what I'll talk about is a concept that's loosely referred to for convenience as will substitutes.
Mm-hmm.
With a will, the law in Australia and many countries overseas allows you to dispose of all of the assets that you own in your sole name at the date of your death via the terms of your will. But one of the doctrinal challenges with inheritance law is the concept of will substitutes, and people are saying with modern forms of wealth and different types of assets that are being created on a regular basis, you don't necessarily have to pass everything through the will, and there may be good reasons why you don't want to pass things through the will. So the common will substitutes are jointly owned property, purely jointly owned property, superannuation, life insurance nominations. You can, and it's probably, sorry, I don't know how I stopped my phone ringing, but there's, you can put assets in a trust, and that is in effect, a lifetime trust, which is effectively a will substitute. You don't direct who those assets go to because you won't necessarily, you can't because they're held in the trust. But what you do is in your will, you can direct who controls the trust after your passing. So it's a good thing to differentiate between what's going to pass in your will and what's going to pass outside your will. And that's where, prudent planning and advice will help. And for example, I just saw this morning a husband and wife, and they have a child, and they were talking to me about their estate plans, and what they said was that they wanted their main residence to go to each other, and then they wanted to split their financial assets between the surviving spouse and the one child. And they were very worried about that because they didn't want they thought it was proper that the surviving spouse get the residence and not have to split it with the child. And when we did a title search, it was discovered that it was a joint tenancy and it was going to pass outside the will anyway. So it's important to be aware of that because with a joint tenancy, the law of survivorship says on the death of the first joint tenant to die, title automatically passes by the law of survivorship to the surviving joint tenant. With a binding superannuation nomination, properly signed, properly witnessed, valid under the superannuation trust deed. On the death of the person that signed that nomination, the trustee of the superannuation fund is obliged to pay the superannuation death benefits in accordance with that nomination.
Of
Now,
course.
if you don't have any tax dependents for both, you don't have any dependents for both tax and superannuation purposes, and you're interested in, making sure the super gets split among a number of different people, there's no problem directing it to the legal personal representative of your estate to be distributed in accordance with your will.
Certainly makes sense. I guess changing tact a little bit, and we hear this all the time when we raise this area of estate planning with clients. It's, I've got my will. Let's talk about investing and savings and all the fun stuff. What often gets overlooked are things like powers of attorney, guardianship, enduring guardianship, guardianship for children. These are the documents. Now, I guess there's probably an added layer of importance for expats, but can you just talk us through the basics of powers of attorney and how they might apply for expats living in different countries?
Yes, well, I think the general starting point is that the powers of attorney are jurisdiction specific. And even in Australia, we have different laws, believe it or not, relating to powers of attorney in the different states and self-governing territories of Australia. Now, we conveniently saw that it was stupid to have, a power of attorney in New South Wales that you couldn't use in Western Australia. So through our legislation, we have something that allows a power of attorney signed in one state to be recognised to allow an attorney to deal with assets that might be actually situated in another state. Okay? And that's how we've dealt with it in Australia. That same treatment or that same arrangement won't happen in overseas jurisdictions. So in the sense that they won't conveniently recognise an Australian power of attorney and allow the Australian attorney to deal with an asset that belongs to the person who appointed the attorney to deal with that person's asset that may be located in Singapore. They may want an equivalent of the power of attorney document in Singapore, and if there is none, if there is no document signed in Singapore, may be that there is a process that you have to go through in Singapore to have the Australian power of attorney recognised. And I imagine that, in Australia we have either the Supreme Court, which is an expensive exercise, or we have something called the Guardianship Division of the New South Wales Civil and Administrative Tribunal, which can sort of recognise different things and help where there are issues. But I think both with powers of attorney and appointments of enduring guardian, they are jurisdiction specific, and you need to be very careful if you're trying to prepare one document for multiple jurisdictions. I think it's more prudent to have separate documents in separate jurisdictions. And in going back to your point, Jarrad, about the enduring power of attorney, I mean, laws are different in relation to assisted dying in different jurisdictions. In Australia, it's permissible. I'm not talking about assisted dying, but I'm talking about having what's called an advanced healthcare directive in your enduring guardianship document to say, I want to be, receive treatment for pain and suffering, but I don't want to be kept alive by machinery or artificially if I'm in such a state that there's no likelihood that I will recover. So that's called either a living will or an advanced healthcare directive. It is recognised in Australia because you can consent to the medical treatment that you receive or you don't receive. If you have a terminal illness, you can use the assisted dying laws to actually permit people to end your life, medical professionals to end your life. But there's a very strict regime that you have to follow, and you have to have a terminal illness. I'm pretty sure that a lot of that may have some application in overseas jurisdictions, but it will be different. It will be different, and you've just got to get good advice in the jurisdiction that you're in to make sure that you're covered. And the bottom line is, why would you take the risk of relying on documents prepared in one jurisdiction that may be needed in another jurisdiction. Nobody knows what's going to happen in the future.
Of course. And I mean, we probably touched on this a little bit in terms of some of the areas you can go wrong, some of the things you can miss or overlook intentionally or unintentionally. But I guess in your experience, what are some of the more common mistakes that you see either expats or Australian residents making when it comes to their broad estate planning?
The most common mistake I see is perhaps a lack of communication between the advisors in the different jurisdictions, and a failure to appreciate by the people undertaking the planning process what can go wrong. And the most common example is, and I've seen it so many times, where you have a will prepared in another jurisdiction that has the usual first clause, I revoke all previous wills. And therefore, it's signed after the Australian will, and all of a sudden, because that will's signed, you've got a potential intestacy in Australia. You've got no valid will. So it's really important, and believe it or not, it was the clients that I saw this morning. They have assets in Poland, they have assets in Italy, and they have assets in Australia. And what I said to them, because I haven't seen the Italian will, I told them they should be getting, they had property in those other jurisdictions. I said, you need to get advice. And they said, yeah, we've got the Polish will. I know they had the Italian will, but they hadn't had the Polish will set up. And what they need in their Australian will. And I said, this is what I'm going to have, is the first clause in your will. I revoke all previous wills except any will signed by me in Poland or Italy. And this will applies to all my assets wherever situated except for Poland and Italy. So it makes it quite clear that we're not revoking those other wills. This will has an operation completely independent of those other wills. And, it's not only me that needs to be aware of that, it's the lawyer in Italy, the lawyer in Poland. They need to see a copy of the will. It's just prudent that they know what you've done, so that these documents aren't, they're sitting together and they're complementing each other and not competing with each other.
That's such a good point. I myself have seen that on one or two occasions with expats where you've got that revoke clause and it's not specific. It just says, I revoke everything. And it's just it's a common, especially the world's getting smaller. People are working overseas. People are traveling regularly. You just got to be alive to that issue. I'm going to sort of pull out a bit of a millennial question for you now. In the world of social media and much more of a digital focus and online assets, cryptocurrency. There's all of these assets.
Joel, you're asking all the hard questions now.
How do you see these sort of considerations? Are they considered Australian estate assets? If I'm a TikTok sensation, I've got cryptocurrency. What's your thoughts on where does assets sort of start and end?
Yeah, very, very good question. One thing that has changed considerably in perhaps the last 15 years is that we are becoming paper light as a society. Everything's online, bank accounts, the dealings with banks, checks have disappeared or mostly disappeared. Everything's online. And one of the challenges that an estate lawyer has is that the traditional paper trail that you had when a person died is no longer there. It's on their computer. And one of the big issues is who has access to that computer, who has access to passwords, who has access to security codes and things like that. Now, if you are significantly invested or involved in the digital world with digital assets or different types of, digital companies and things like that, you may want to appoint a digital executor with expertise in that area in addition to a normal executor. That's one consideration. The other thing, often we talk about Facebook and photos on particular social media sites and things like that. That is a very sort of unsettled area of the law, because it's the conflict of laws situation. Where is the social media entity that controls the investment, that controls Facebook, etc.? And I think the better view is that that you can't dictate to a social media entity in your will what they must do. The jurisdiction just doesn't extend that far. So what we try and do and it can be in wills, it can be in powers of attorney, we try and give the attorney or the executor as wide power as possible, and we have specific clauses drafted for this, to deal with digital assets, to have the power to do whatever they need to do. Now, whether that will be effective if we produce it to an overseas bank, or we produce it to an overseas company that deals with digital assets, we don't know. But at this stage, it's the only thing that you can do. It's the best thing that you can do. In addition to that, you need to, when I talk about having a list of your assets, and security is a big issue here, but you need to have a list of your digital assets as well. And I know it's quite risky to do, but somebody needs to know where your passwords are for all the digital assets, and where they can access them, where it's going to be secure. There's no perfect solution to that. I know there are a number of commercial entities that offer that, luxury. You pay them a price and they keep everything secure and it's there for you. But as with everything else, it's about keeping it up to date. Now, I know in our own work situation, we have to change our password for cybersecurity purposes, virtually every 6 weeks. It's a pain in the backside, I've got to tell you, but I understand the reasons why. So you need to have a complete record kept safe of the passwords, etc. They need to be up to date. And just to illustrate some of the practical problems, if you're a very introverted person and everything you own and all your dealings, even, you might do your own tax returns, it's all on your computer, and you pass away, we've had to get computer forensic document experts to break into computers to get the required information to actually, breaking is probably not the word, but hack into computers or whatever to get the relevant information that you need to take the next step. So it is a good question, Joel, and it's a very real issue. And you've just got to do the best you can, being mindful of the potential issues and how best to resolve them. And I think communication is the first thing, and making sure that the relevant details are somewhere that can be found when you pass away, somewhere secure. And the second thing is just in the documents that may impact either during your lifetime or after your death, try and give your attorneys or your executors the powers to deal with those assets, give them as wide as power as possible, and hope that might influence somebody overseas to allow an Australian executor or an Australian attorney to do something in respect of one of your digital assets.
Look, you raised some very valid points there, and I think it's something that we all need to consider much more broadly as we move into a much more sort of digital, paperless, cashless sort of society, and sort of understanding where the assets more or less exist and how do our beneficiaries access them. Another, I suppose, one of my favorite things to talk about generally, for a lot of people and a lot of clients, is the value of different types of cover around life insurance and how they can be used, particularly in estate plans, more or less, through things like estate equalisation. How do you view the use of, for example, life insurance or any other policies, more or less, inside estate planning documents?
Well, life insurance can be a will substitute, and you can nominate a person by virtue of the contract that to receive your life insurance benefits that might take it out of the will, and it can be a will substitute. By the same token, it can be directed to your estate if there is no beneficiary nominated. And it has a good asset protection advantage in the sense that, generally speaking, superannuation and life insurance are protected from, and I've been involved in big court cases around this, but are protected from estate debts. So apart from, funeral and testamentary expenses, they're protected from debts that may have been incurred during lifetime. And we had a big case involving our Australian taxation office where a partner of a big accounting firm passed away, and he had technically his estate was insolvent, and but he had assets, superannuation, significant superannuation that didn't pass through the estate, and the tax office was left with some huge amounts owing to it, both pre-death and after death. And we actually went to court, and it was a big court case about the order of application of assets and the extent to which life insurance and superannuation was protected from paying the tax debts and things like that. And I think the outcome in that case, from memory, was that it didn't help with the pre-death debts. They could be used to pay the pre-death debts, but the post-death debts, they were protected from being sort of grabbed at by the tax office to satisfy their liabilities.
Wow.
Certainly a lot to think about. I think in structuring what's included, what's not. Now, I guess one of the other common situation scenarios with our clients, they move overseas. There's new relationships. There's children. There's the separations, divorce obviously takes place as well, not just for expats but for residents as well. So I guess, Gerard, thinking about marriage, about divorce, about having children, growing your family, how does all of this, and I mean, what do expats need to think about when it comes to their wills, their powers of attorney, their general estate planning?
Okay, it's another good question. You certainly both have done your homework. Wills, if you're going to make a will and you know that a marriage is going to happen at some future stage, it's better to make the will in contemplation of the marriage, even if you're not sure of the date of the marriage, because under Australian law, marriage automatically revokes a will, which is the case. And I think with divorce as well, you can make surprisingly, you can make a will in contemplation of divorce, because divorce revokes a provision, a will provision in favour of the divorced spouse, unless you can prove that you still wanted that provision to apply. So that's why we say jokingly, but it is true, you can make a will in contemplation of divorce. So you can make a will in contemplation of marriage specifically to a person, being conditional on the marriage taking place, or in contemplation of marriage generally, because you're with the right person and you think they're going to end up being married. You're going to end up being married. So that's one thing. And the other issue is if we're talking about the estate planning documents, they obviously need to be looked at again in respect of marriage, divorce, when children come along. For example, if children come along, you may want to think about the appointment of a testamentary guardian to have legal responsibility for your child in the case where both parents are not alive. And, that when it's a sophisticated decision that needs to understand effectively the child's personality, the personality of the family member or friend who will have the responsibility for that child, where that child's going to live. You obviously don't want to impose the financial obligations on the guardian, the testamentary guardian, to looking after that child. So, there has to be wide powers given to your executor and trustee in the will. This will be probably a substitute executor or trustee that you've named, to release income and capital for the benefit of the child whilst the child is a minor. Now, I personally like the trustee and the guardian to be a testamentary guardian to be different people, because they tend to keep an eye on each other. The testamentary guardian, who has the legal responsibility for the minor child, makes sure that the trustee is doing the job correctly. They're investing prudently. They're getting a good rate of return. That the capital and the income is growing for this minor child. And likewise, the trustee keeps an eye on the guardian. If the guardian says, I want money for school fees, the trustee says, that's fine, yeah, I'll give you the $20,000, just give me the school fees account and I'll pay it direct. So it's a good check and balance. And I mean, people are honourable mostly, but some aren't. And it just makes sure that, the right thing has been done by the people who have the particular responsibilities. Now, in terms of other documents like appointments of enduring guardian and powers of attorney, I don't think the rules, I'm pretty sure the rules relating to marriage and divorce don't necessarily mean there's an automatic revocation of them. There was an issue with superannuation nominations as well, and there were many cases that dealt with, a person divorcing, having revised their will, but forgetting to revise their superannuation nomination where it went to the former spouse. So they all have to be looked at. I think there are some rules that will soften the legal result in that situation, but it all needs to be looked at holistically and at the right time. And the right time is obviously, when you're going through a divorce, for example, everything's everywhere and you've just got to bring it all together, and you've got to, it can be an emotional time, but you've got to, or a breakup of a relationship, you've got to take one step back and say, okay, I'm going to be starting out on my own. I need to know what I've done, and I need to, put it down on paper. Even though we're going paperless and digital, I'm still a person that likes paper. I think it's a superior product. I like to think on paper. But, we need to say, well, this is what I've done, and now that this is happening, this is what I need to change. And advisors are the best people to, take you through that, obviously, probably an emotional time and an unsettling time in your life.
Absolutely. Look, it's a really good point. And I can't tell you the number of times we've had new clients come to us, we've gone through the superannuation, various beneficiary nominations, only to find that there's an ex-spouse still nominated there that, from a relationship that ended years ago. They just hadn't checked or hadn't, taken the time to review these things. I guess one of the other, common scenarios relevant to quite a number of our expat clients is when they move back to Australia. So let's say they've done the right things. Let's say they've lived in Singapore. They had a will in Singapore. They've got a will in Australia. But now it's time to move back. We're not going to retain any assets in Singapore, or maybe we are. What do they need to think about in terms of their will, their estate planning when they move back to Australia?
Well, I think if they've spent a significant amount of time outside Australia, they may want to, go back and visit the jurisdiction that they lived in at other times, just for old time's sake. If you've got documents in that jurisdiction that covers your affairs or your assets in that jurisdiction, and you're not going to bring those assets back, it's okay to leave the documents in place. In the end, even if you realise the assets and you bring them back, they just won't have any legal effect in the other jurisdiction. But it's good to still have them there. If you're confident that you're going back to Australia after a long period away and you want to stay home, well, and you're bringing back all your assets, you don't need to worry too much as well, because you just, you can destroy the documents, but I'd just keep them anyway, just as a precaution in case you've forgotten something. Does that answer your question, Jarrad?
Yeah, look, it certainly does. I mean, I feel like we could go through that many different scenarios. But yeah, I think it's one of those common things that, a number of expats ask, what should I do with those documents when I go back? And yeah, I think it really clarifies it well.
And you both would be across the, making sure your tax situation in the departing jurisdiction is up to date and finalised, and you don't have any tax issues there, and then making sure that the tax situation in the coming back to Australia is up and is running again, and your advisors in Australia are aware of what's happening. And there are so many different issues. Superannuation, bringing that across from one jurisdiction to another. Are there going to be implications in doing that? So you just got to work through it on a case-by-case basis and really looking at the particular assets in each jurisdiction and your affairs.
Absolutely. Look, certainly an important one to clear that tax bill in Singapore. You won't be getting too far out of the country if you don't pay your dues. In fact, most companies have to withhold the last month's pay, and you might even find there's a bit more tax to pay. So an important bill to be mindful of, and a topic for another podcast, I think.
I'll have to tell that to my brother who's working in Singapore at the moment for a hotel group.
A very important one. Look, Gerard, we might wrap up there. I'm super grateful for your time. As I said earlier, there's just so much we could explore when it comes to estate planning, but I think you've really given our listeners, our audience, our community a lot to think about. Certainly clarified a lot of the key points. Some great questions from Joel in terms of the insurances and everything else to think about. So on behalf of us, our community, the podcast, a huge thank you for giving us your time today. We'll pop your details in the notes so people can reach out if they have questions. As you said, make sure you've got a will, make sure you're covering the basics. Don't leave it until too late. Just get it done. But no, huge thank you for your time, Gerard.
And thank you both, and very good questions. So you're obviously very good advisors.
I'll take that compliment.
Thank you very much, Gerard. We'll chat soon.
Yes, thank you, Joel and Jarrad. Thank you.
So thanks so much for tuning into that. There's so much information and knowledge that we get out of Jarrad, in this podcast. So, if you do want to get in touch with Jarrad or myself or Jarrad, we will be able to provide our contact details in the bio of this. As mentioned in our first podcast episode, we'll be releasing a new podcast each month on the last Wednesday of the month. We're always looking for new content, new topics to sort of talk about. So if there's any sort of content that you would like to have fleshed out, we'll also be interviewing people with these sort of specialized areas of advice to help benefit, the expat community and Australians living all over the world. So the podcast is on all major hosting services. So you'll be able to find us, subscribe, check out our resources we're creating as part of this podcast. And of course, please leave us your questions. Send them through. We'd love to hear from you. We'd love to hear your feedback. It's just a really good opportunity for us to engage with lots of Australians, no matter where you live around the world.
Wonderful. Thank you very much, Joel. Look, yes, as you say, if this appeals to you, if you're enjoying the content, getting value from it, we'd love a review. 5 stars, please, if you can. If you have any suggestions on how to improve, as Joel said, more content, more ideas, flick us a note. You'll find our contact details in the show notes. We'd certainly love to hear from you in any other ways you feel we can add more value to the wider Australian community, wherever you may be. So yes, we'd love to hear from you. As Joel said, follow us on socials. We're at Money Side Up on all the major channels. So do follow us. Next month, we've got a fantastic speaker lined up already. We've got some great speakers actually lined up over the next few months, covering all things from how to get the best rate on your foreign exchange to things like depreciation on investment properties back in Australia. So a lot to cover, but a huge thank you for tuning in, for giving us your time. Hope you've got a lot of value out of it. As Joel said, end of financial year rapidly approaching, so don't miss out. Seek advice early. But again, thank you, and we look forward to seeing you in the next episode.
Goodbye all.